This is part two of the lecture on free appropriate public education. My name is Dr. George Giuliani from Hofstra University, and we left off on part one talking about the free component of a free appropriate public education. And free is an easy term to understand for the most part. But where things get complicated, where things get a little trickier, is in the idea of appropriate. What does it mean to provide a child with an appropriate education? And the actual meaning of the term appropriate was first addressed by the U.S. Supreme Court in the case Hendrick Hudson District Board of Education versus Rowley. And I'll talk about this case in detail in this lecture, and I'll refer to it as the Rowley case. But ultimately, an analysis of whether a school system is meeting its legal obligation under the federal law begins with a consideration under the Rowley case. Now, the facts presented in the Rowley case were pretty straightforward. The case concerned a first grade girl with a hearing impairment named Amy Rowley, and she was a student at the Furnace Woods School in Hendrick Hudson Central School District in Peekskill, New York. Now, Amy, this first grader with the hearing impairment, had very minimal hearing, but was an excellent lip reader. And when she was only in first grade, a dispute arose between parents and school officials. And no one challenged her eligibility for special education. No one challenged Amy's eligibility for special education and related services under the federal law, Public Law 94-142, the Education for All Handicapped Children Act. The school district and the parents disagreed about what services were necessary for Amy. So Amy's this first grade girl. She has a hearing impairment. No one is questioning the classification of hearing impairment. No one's questioning eligibility for special ed. What they are questioning, where a debate arose, is what were the services that would be necessary for Amy? Now, interestingly, Amy's parents, who are also deaf, argued that the school district should provide Amy with a sign language interpreter in order to allow her to understand her teachers and classmates. So Amy's parents, who felt Amy was not getting what it was that she needed, Amy would need a sign language interpreter in order to allow her to understand what was going on in the classroom. Now, the school officials at Amy's school contended that the services that Amy was already receiving were appropriate. Amy already received speech and language therapy and the services of a teacher of the deaf, in addition to the program available in the classroom. The school also outfitted her with an FM amplification system as well. So Amy was receiving all of these services, but Amy's parents contended, well, we want all of these services, but we also want a sign language interpreter in the classroom. School officials argued that Amy was achieving good marks with the programming provided and therefore did not need any additional services to succeed. But Amy's parents maintained that Amy's hearing impairment was such that only a fraction of the information that was available to her through the audition and speech reading, and thus an interpreter was necessary to provide her learning opportunities comparable to that of her peers without disabilities. Amy's parents made the argument that she was maybe doing well in school, but that she wasn't getting nearly the amount of information that she should be getting, and therefore she needed an interpreter to provide her with the learning opportunities comparable to that of her peers without disabilities. So even though Amy was getting good grades, even though Amy was doing well in school, her parents were saying that she wasn't getting all the information necessary. She wasn't actually getting all the information that was happening in class. So the parents filed a state complaint, what we'll call a due process hearing, to contest the denial of the interpreter services. The school district denied interpreting services, and the parents said this is not acceptable, and they filed a complaint calling for a due process hearing. And there is a hearing on the matter of whether or not Amy should receive interpreter services. And the hearing officer in the case ruled in favor of the school district. The hearing officer said that Amy was getting good grades, that Amy was doing well in school, and therefore did not meet the requirements under the law in order to receive an interpreter. The parents were displeased with this decision, they were unhappy with the decision, and ultimately decided to appeal in federal court. And the federal court took the case, and upon appeal, the federal district court ruled in the parents' favor. They rule in the parents' favor, and when it went to the Court of Appeals, the Court of Appeals affirmed the ruling. So the hearing officer originally at the first level, at the due process, rules in favor of the school, but when they go to federal court, Amy's parents win, and now interpreter services need to be provided, and the Court of Appeals affirmed the ruling. The school district is unhappy with this decision, and so they ask the United States Supreme Court to hear the case. And the U.S. Supreme Court takes on the Rowley case. So this case becomes the first case in special education to actually make it to the United States Supreme Court. So the Rowley case now gets to the U.S. Supreme Court in 1982. And in Rowley, the Supreme Court identified two areas of inquiry, two areas to look at in determining whether or not the state or the school district here has met the requirements of a free, appropriate public education. How do we know if the school district has met the requirements of a free, appropriate public education? And there are two questions that need to be asked. First, did the state comply with the procedures set forth under the federal law, Public Law 94-142? Today we'd call that IDEA. Again, was there parental consent? Was the evaluation that was done non-discriminatory? Were the parents involved in the decision making? Was an IEP development? Ultimately, did the state comply with everything that we have discussed in terms of meeting the requirements under the federal law? And second, was the IEP developed for the particular child so that the child received educational benefit from the program? So the Supreme Court says when we're determining whether or not an appropriate education has been provided, first, did the state do everything right? Did the school district do everything it was supposed to do in terms of the evaluation, in terms of getting consent, in terms of providing an IEP? Did it do everything that we have discussed in terms of following the law? And second, was the child's IEP developed so that we can say that the child received educational benefit from the program? Those were the two questions the U.S. Supreme Court said needed to be addressed. And the Supreme Court said that if these requirements are met, the state has complied with the obligations imposed by Congress, and the courts can require no more. So Rowley, the Supreme Court says in Rowley that if you meet these two requirements, if the two requirements are met, the state has met the obligations imposed by Congress, and the courts can require no more from the districts. So the U.S. Supreme Court looks and it says, you know what? In Rowley, the school district did comply with the standards, and Amy was receiving educational benefit from her IEP, and ultimately the U.S. Supreme Court overturns the Court of Appeals decision and rules in favor of the school district. And it held that the public law, Federal Law 94-142, did not require schools to proportionally maximize the potential of handicapped children. So this is a huge decision because the Rowley Court in the U.S. Supreme Court says that school districts did not have to maximize the potential of children with disabilities. That was not the role here of the school districts. The role of the school district was to look at those two standards. Did we comply with the procedures, and did the IEP that was provided provide educational benefit for the child? And we'll get into that more in part 3 of the lecture. So this ends part 2 of the lecture on free appropriate public education. You can now move on to part 3.